Next matters are State versus Shields, CR 2021-412 and 74. I'll note that Mr. Shields is present in custody in person. Mr. Benjamin, his attorney, is here. Ms. Ortman is here from the county attorney's office. Mr. Benjamin, I think you were recently appointed in this matter, am I correct?
Yes, Your Honor.
Okay, and can you give me an update on what's happened since your appointment? And was that literally a week ago?
No, Judge, it was last setting, I think it was about a month ago.
Okay.
I had, after the setting, I went down to the jail, spoke with Mr. Shields in person. After I'd had an opportunity to review his case and discuss the issues that he felt rose to the level of a manifest injustice. I do not believe they do. By the end of that conversation, he didn't change to me that he was going to stand a plea, though. Today in court, he seems to.
Okay.
I don't know anything beyond that.
Okay. Mr. Shields, as I probably told you before, you have the right to remain silent. Anything you say could be used against you. You'd like to be heard today, sir?
Yes, sir.
Okay.
I'd like to say I believe it was a Rule 15.7C2, I believe it was. I don't have that paperwork with me that I filed to have the charges dismissed with or without prejudice. I had Dan Benjamin appointed to me. He was supposed to come down to the Gila County Jail to do a legal visit with me to go over the missing discovery and my case. Dan Benjamin showed up to the Gila County Jail on March 14th to do a legal visit. Dan Benjamin had stated that he does not have my file, that he is still receiving it from various sources, that he still has not even seen my indictments yet, but he has already talked to Jessica Ortman about my case on the telephone, that if I did not sign into the plea offer and go forward with it, I would be doing 12 years in prison. I believe that that's ineffective assistance of counsel. I believe at this point Dan Benjamin has been coerced by Jessica Ortman about my case. Dan Benjamin had asked me, what is it, what do you think you're missing in discovery? And I'm showing him, and he says, well, it looks like you have it all right there. Well, it's not that it just looks like that I have it all right there, because it's just simply not all right there. I'm missing discovery. It's not CCA that Jessica Ortman says it is. After I've signed the plea, I have paperwork showing up from the Department of Child Safety, transcripts that I've never seen before. In these transcripts, it states to the child that he will be seeing a very nice doctor lady that's going to check him from head to toe. I promise no shots. Come this way and wait in the waiting room. And I believe that, again, not only were the transcripts exonerating evidence for me, but I believe that the missing, report from the very nice doctor lady is going to be exonerating evidence also. So therefore Dan Benjamin was unable to go over anything with me because he just simply doesn't have any of my paperwork. So we can't see what missing discovery he's got versus I got. I would like to speak to a public defender who would actually go over these charges with me, because I'm not understanding exactly the state's charges against me. And it goes like this. If I'm being charged with 13-3623B under circumstances other than those likely to produce death or physical injury to a child, so it's other than those. What are those circumstances? I'm not being charged with other circumstances likely to produce death or serious physical injury. So therefore, if it's other than those, I'm not understanding what those other ones are. I have a plea offer here for endangerment, a Class 6 felony, but from my understanding here, 13-1201B, endangerment involving a substantial risk of imminent death is a Class 6 felony, In all other cases, it's a class 1 misdemeanor. You know, and endangerment does not require that the person who is endangered actually be physically injured to constitute endangerment. And endangerment makes it's only a felony if it involved a substantial risk of death to another. Well, the definition of only is existing with no other or others of the same kind, and the definition of death is the act of dying or the state of being dead. So I'm not understanding these charges because I'm being charged in a foolish plea offer of endangerment being a class 6 felony. I have a summary from the Department of Child Safety right here where they found no criminal conduct. It's not a high profile case, and they surely don't describe any safety issues. Out of my paperwork, the discovery that I guess I'm allowed to see never indicates any safety concerns. The police reports the child never had any injury. The reports never indicated a risk of death. So I'm not understanding why I'm being charged. Why the plea is being embellished by Jessica Ortman, to a class 6 felony, when it never indicated a risk of death at all. When it comes to the aggravated assault on an officer...
Hold on just a minute. We're here, so first of all, you've asked for a new attorney.
Yes.
Mr. Benjamin, you indicated that you went and spoke with Mr. Shields at the jail. Is that
I did,
correct?
Your Honor.
I'm going to deny your request for a new attorney. Sir, I think what you've gotten into is sort of you're making an oral motion to withdraw from the plea. Okay? I'm going to deny that today. I'm going to move forward with sentencing. Okay? So, Mr. Shields, I need you to tell me your full true name.
Well, I guess my name's Ryan Thomas Shields.
What's your date of birth?
3/14/1986.
Court has previously accepted the plea. The court will now accept the terms of the plea agreement. Mr. Shields, it's the judgment of the courts that you are guilty in the 2022-74 of amended count 1, aggravated assault, a class 5 non-dangerous but repetitive felony from May 16th of 2021. Additionally, in the 2021 412 matter, it is the judgment of the court that you're guilty of amended count 1, endangerment, domestic violence committed between March 1st of 2021 and July 30th of 2021, a class 6 non-dangerous, non-repetitive offense. Let me just look at the plea agreements for just a moment. And the court will find that the prior felony is attempted weapons misconduct, CR 2013-641 in Pinal County Superior Court from April 13th of 2013. I've reviewed the pre-sentence report, and it appears to follow the plea that was entered by the parties, which calls for 3 years in the Department of Corrections on the 74 matter, and also probation in the 412 matter. The court is inclined to move forward with that. I'll note that the defendant, as of today, would have 534 days credit since we are 97 days from January 2nd. Ms. Ortman, anything additional the state would like to recommend today?
No, Your Honor, and I do agree with that time calculation by the court.
Mr. Benjamin, on behalf of Mr. Shields, anything else you'd like to add?
Your Honor, I believe the time calculation would be 544, not 534.
47? Actually, it is. 544. Thank you, Mr. Benjamin.
Nothing
Okay.
else, Your Honor.
Mr. Shields, anything you would like to add before I sentence you today?
I mean, I would just like to add, out of my criminal history, I've never gone through court like this before. Gila County can't get a lot of it right. They can't get my days right. They can't get my charges right. I'm just glad that I don't have to hear the saying anymore that's Gila County for you. That's all I have to say.
And council, so, okay, actually, I'm sorry. The prior, okay, thank you, sir. The prior felony, Madam Clerk, is the burglary charge from attempted burglary from February 12th of 2018 out of Maricopa County. That's the prior felony. The other one that I issued is an aggravator, which is set forth in the plea. Okay. Okay, as far as 2274, the court finds one aggravator, which is a second felony, that's not a historical felony. Court finds that probation is not appropriate. Considering that aggravator, the court finds that the maximum term is appropriate. It is the judgment of the court that the defendant be imprisoned for the maximum term of 3 years. I'll find that he has 544 days credit as of today. I'll order that community supervision be waived as he will be coming out on probation. I'll order the following financial obligations: a $20 time payment fee, $20 probation assessment, and $500 to the cost of prosecution. I'll order that those be entered into the tax intercept program upon his absolute discharge from the Department of Corrections. I'll order that the Department of Corrections notify the court upon his final release type and date. Moving on to 2021-412, the court will find pursuant to the plea that probation is appropriate. Again, I'll find one aggravator, which is the prior felony. It is the judgment of the court that imposition of sentence is suspended. The defendant will be placed on supervised probation for a period of 36 months that will date from his absolute discharge from the Department of Corrections. Ms. Ortman, I don't see any restitution request at this point. Is that still correct?
Correct, Your Honor.
I'll order a $20 time payment fee, $20 probation assessment, $50 to the address confidentiality program, $50 to the family offense assessment, $500 to the cost of prosecution. I'll order that the defendant make monthly payments of $35 a month, beginning 30 days after his release from the
I can't
Department of...
afford that, Your Honor.
Just a moment, sir. $35 a month and beginning 30 days after his release from the Department of Corrections until paid in full. There also is a statutorily required $65 monthly probation service fee, again beginning 30 days after his release from the Department of Corrections. I'll order that he complete the Wise Choice Alternatives program. I'll order that he complete a substance abuse screening and any recommended treatment. While on probation, he's not to consume alcohol, not to be in bars or liquor stores. He's to have no contact with Leanda Rica or her children. Mr. Shields, if you have difficulty making those financial payments, you need to check with your probation officer. They'll work with you if it truly is something where it's your inability to pay. You have the right to petition for post-conviction relief from the orders of this court and to have a lawyer represent you. If you cannot afford a lawyer, one will be appointed to you. If you cannot afford copies of the necessary records and transcripts, they will also be provided to you at no cost. If you want to petition for post-conviction relief, you need to do so within 90 days of today's date or you lose the right to seek that relief. I'll order that all additional counts in each of these cases that were dismissed pursuant to the plea are dismissed. Mr. Shields, a felony conviction suspends your civil rights, the right to vote, serve as a juror, hold public office, and bear arms. As this is your second felony, application to restore civil rights cannot be filed until completion of probation or absolute discharge from the Department of Corrections. Applications to restore civil rights can be obtained from the clerk of court at no cost and filed without a filing fee. Mr. Shields, I'll need you to come up, sign for your review rights, and also give us two sets of fingerprints.
One thing, Judge, right in the plea offer that you didn't discuss is that I was charged with 2 Class 5 felonies for destruction of a public jail twice about 6 months ago, and those were in the plea agreement also. Those would not be used against me.
Okay.
Is that still to be true, or
Yes, sir.
has that changed?
Yep, that's on page, it's line 10 of page 3. One of the stipulations in the agreement is they were not going to bring charges arising out of GCS DR 2023-09-00924, 2311-0923. Yes, sir.
Okay, and who is it that helps me out with post-conviction relief?
You'll get a notice of post-conviction relief in your rights, and if you decide to do that, you can file that notice, at which point the clerk of court will determine whether you're eligible for an attorney. Okay, that'll be all done on Mr. Shields' matter.
The whole hand needs to be on the bar.
Oh, on the window.
Thank you very much.
It is,
And then you can sign your papers while I get your other one. Right here.
Probation is out, there's 3 days to final thing, today's date 40 to 24.
this is a prior one from the original charge, right? It's an older date of offense, new case,
On which one?
Schnack.
Looks like it's a 2023 DR.
Right.
Officer
And
Smith,
I
can
think
I
the new
have,
one was like
Mr. Papineau just come down and sit by that microphone? Sir, if you want to make your way carefully down in front of the microphone.
I just want to make sure when,
If you want to stay on that, just say, you want to stay up there, sir?
Yeah.
Right down there, excellent.
pointless.
Yes, you have to. Okay, and then you're right.
Yeah.
Okay, you're all done. Big piece here.
Did we do O'Connell? Okay. Oh, I see. Okay. Okay.
Thank you. Okay. Next matters are State versus Papineau.